Go ahead on reset Jacks. I mean Creekmore. Mr. Samuel and Mr. Boyd, how long a reset we need on Creekmore?
We're setting that for trial.
Trial?
Yes.
Oh, we have a trial, hold on. Yeah, got any additional memos on that?
No, we not getting memos on that. Uh-oh.
I'm sorry.
There you go.
I'm gonna give you a reset.
Oh,
And this is.
okay.
Yeah, Mrs. Sam.
Thank you, man.
You're welcome. You as well.
What's wrong? Court is in session in cause number 324650. Cause number 325880. Both cases of style of state of Texas versus Patrick Lee Jacks. Mr. Jacks, is that your full name?
Yes, sir.
Mr. Jacks, would you please raise your right hand? Mr. Jacks, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Jacks, you may put your hand down. How are you doing, Mr. Jacks?
Pretty good.
That's good, Mr. Jacks. You here represented by your attorney, Mr. Alvin Samuel. Mr. Samuel, how you doing?
I'm great, Your Honor.
That's good. Mr. Samuel, do you waive a record in Mr. Jacks' cases?
We do.
Mr. Jackson, cause number 324650. The case is style of state of Texas versus Patrick Lee Jacks. The information alleges that on or about September 15 of 2019, while you're in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated with an open container. Mr. Jacks, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Jacks, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
Yeah, you're right. Right.
Okay,
Yes, sir.
okay, now, Mr. Jacks, I have before me a document that is titled Misdemeanor Plea Admonishments. Now, Mr. Jacks, do you recognize this document?
Yes, sir.
Now, Mr. Samuel, I see you had checked, it was a Class B misdemeanor. May I make the correction to driving while intoxicated first?
Yes, sir, Your Honor.
Okay, Mr. Jacks, you have any objections to me making the correction? Okay, now, Mr. Jacks, this is a Class B misdemeanor, and because it's an open container, alleged in the information, the range of punishment is confinement in jail for at least 6 days, but not to exceed 180 days, a fine not to exceed $2,000 of both such fine and confinement. Do you understand the range of punishment?
Yes, sir.
Now, Mr. Jacks, on page 2 of this document, Mr. Jacks, there's a set of initials PLJ on a line next to a box that says check no contingent, which means no contest. Are these your initials on this document?
Yes, sir.
On page 3 of this same document, Mr. Jacks, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
And on the next document, which is titled trial court certification of the defendant's right of appeal, do you recognize this document?
Yes, sir.
Is that your signature above the line that's titled defendant?
Yes, sir.
And I have another document here on paper that is titled discovery certification. Do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled defendant? Now, prior to signing initially these documents that I've just mentioned to you, did your attorney, Mr. Samuel, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment, and state you'd like to offer both State's Exhibit 1 and State's Exhibit 2 to probable cause affidavit?
Yes, Your Honor.
Any objections?
No, sir.
No objections. State's Exhibits 1 and 2 are admitted. Mr. Samuel, you've advised and counseled Mr. Jacks. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Jacks, your attorney, Mr. Samuel, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
Mr. Jacks, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
90 days jail probated over 1 year,
Okay,
$700 fine for
Okay.
support call,
okay,
60 hours community service,
okay,
DWI education course,
okay.
and drug and alcohol assessment.
Okay, Mr. Jacks, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During this 1 year probationary period, you'll be required to pay a fine of $700 plus court costs of $407, which comes to a total of $1,107. That's in fine and court costs. You will be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will be required to pay a Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total, and you will also be required to pay a court-appointed attorney's fees of $250. Now, your total monthly installments for this case is $200 a month. Mr. Jax, will you be able to pay the $200 each month?
Yes, sir.
Okay, Mr. Jax, you will also be required to perform 60 hours of community service, attend and complete a DWI education class, and you'll be required to have a drug and alcohol assessment, and you'll also be required to adhere to the other standard terms and condition of this probation. Mr. Jax, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Jax, I'll follow the plea bargain agreement that you have entered into with the state. Now, the next case is cause number, I think that was dismissed, cause number 325880. State, what is your
The state is
recommendation?
moving to dismiss that, Your Honor, based on the wishes of the victim in that case.
Okay. Mr. Jax, cause number 325880 will be dismissed, and I'll be signing the dismissal in a few minutes. Mr. Jax, you're gonna stand on the X next to your attorney, and you're gonna follow the directions of our court clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day. Jax.
I think that's all I have, Your Honor.
Okay, Mr. Samuel, once you finish signing the probation papers, you'll be free to go, and you have a blessed day. You got a dismissal that's coming through. And
You done with me?
I'm still on the 17th. I can put it back on.
Ebony Jones.
Certification or recommendation for misdemeanor, felony in this state or in another state. And that you have no further charges. Once you review that, there's a master. All right, that's it. Thank you.
Court is in session in cause numbers 322-716, cause number 323-414, and cause number 323-416. All three cases are styled the state of Texas versus Ebony Antoinette Jones. Ms. Jones, is that your full name? How are you doing, Ms. Jones? I'm doing fine, thanks for asking. Ms. Jones, would you please raise your right hand? Ms. Jones, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Jones, you may put your hand down. Ms. Jones, you're here represented by your attorney, Mr. Don Boudreaux. Mr. Boudreaux, how are you doing?
Yes, fine, sir.
That's good. Mr. Boudreaux, do you waive a record in Ms. Jones' cases?
We do.
Ms. Jones, in cause number 323-414, I have before me an information that alleges that on or about February 6th of 2019, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of possession of a dangerous drug. Ms. Jones, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Jones, how do you plead? Guilty, not guilty, or no contest? Now you pleaded,
No, we plead guilty.
Oh.
now you're pleading guilty?
Yeah.
Okay, now are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Okay, you say yes?
Yes.
All right, now, Ms. Jones, I have before me a document that is titled the misdemeanor plea admonishments. It's also labeled as State's Exhibit Number 1. Do you recognize this document?
Yeah.
On page 2 of the same document, there's a set of initials on a line next to a box that's checked guilty. The initials are EJ. You place your initials on this document?
Yes, sir.
On page 2 of this same document, Ms. Jones, there's a signature above the line that is titled defendant. Is that your signature?
Yes.
On the next document, Ms. Jones, there is this document is titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document?
Yes.
And is this your signature at the bottom of this document?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that? I also have before me a document that is titled Discovery Certification. Ms. Jones, do you recognize this document? Is this your signature on the line that's titled defendant?
Yes, sir.
Now, Ms. Jones, prior to signing and initialing these documents, did your attorney, Mr. Boudreaux, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State's 1?
Yes, Your Honor.
Any objections? No objections. State's Exhibit Number 1 will be admitted. Mr. Boudreaux, you've advised and counseled Ms. Jones. Is there any evidence that she is currently mentally incompetent to stand trial?
No, sir.
Ms. Jones, your attorney, Mr. Boudreaux, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Jones, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, the plea agreement is for case number 323-414, and it is for 6 days, time served with court costs to be taxed and retired. And additionally, in exchange for Ms. Jones' plea in this case, the state will dismiss case numbers 322-716 and 323-416.
Okay, Ms. Jones, the state is offering that you serve 6 days in the Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail on this case because you've already served 6 days in jail. Therefore, you'll be given credit for time served. The court cost in this case, Ms. Jones, is $337, but you would not have to pay the court costs in this case either because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Cause number 322-716 and cause number 323-416, both cases will be dismissed. Ms. Jones, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer? Ms. Jones, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Jones, please stand on the X next to your attorney. You'll follow the directions of our court clerk. Once you finish following her directions, you'll be free to go. You have a blessed day, and I'm signing your dismissals. And you'll be able to get a copy of the dismissals before you leave as well.
Thank you, Judge.
You're welcome.
Thank you, sir.
You're welcome, Mr. Yes.
That's okay.
She's gonna get her dismissals too. They printing off now. That's the first one. And the second one is being printed. Okay, you have a blessed day, Mr. Jones.
Thank you.
Mr. Boudreaux, is this your last case?
Yes, sir.
Okay, you're free to go and you have a blessed day.
Thank you, sir.
You're welcome.
We also submitted a dismissal.
Judge,
Yeah, we're gonna do.
I submitted a motion to dismiss also, and Yolanda Pollard, 320196. That was the one we had
With
reset
Auburn?
her. Yes,
Right.
sir. We'd reset her, but she added her back to the docket.
Okay.
And, Your Honor, we also submitted
I think you have one on Kimber's case. Mr. Reynolds?
Yes, Judge, I'm here on Ethan Smith, and I did not have him in front of me this morning, Judge, but I
Okay,
believe
okay.
he had a pending felony.
Yeah, I have, actually, we have Mr. Michael Gilder and Mr. Ethan Smith present in court, and both their cases were reset. Both of their felony cases were reset. Is that correct, Mr. Gilder? And Mr. Smith, is that correct? Okay, so Mr. Reynolds, do you want us to reset these misdemeanor cases on the same day of the felony cases?
Yes, sir, Judge, please, if the court would do that on the same date as their felony case.
Okay, so Mr. Smith and Mr. Gilder, your case is going to be reset with your felony cases. Mr. Gilder, stand on the X in front of our court coordinator, and once he finished, Mr. Smith, you'll stand on the X and your case will be reset. Mr. Smith, once your case is reset, you'll be free to go and you have a blessed day. Mr. Gilder, once your case is reset, you'll be free to go as well and you have a blessed day. And Mr. Reynolds, this will conclude your cases. You are free to go and you have a blessed day.
Thank you so much, Judge.
Okay, you're welcome. David Alexander Oseguera Borjas.
He's here, Judge. That's a plea. It's turned in.
Right, I got it.
Before we do that plea, can I make 2 announcements so that my other 2 clients can get out of here?
Hold on a minute. Let's see. Mr. Borjas, just have a seat.
Okay.
We'll call you back up.
Lawrence Westbury on the announcement docket.
Okay. Mr. Westbury, would you please come forward? This is cause number 330012, case of style of state of Texas versus Lawrence W. Westbury or Lawrence Wayne Westbury Jr. Mr. Westbury, is that your full name?
Yes, sir.
Mr. Westbury, how are you doing?
Good.
That's good. Mr. Westbury, you're here represented by your attorney, Mr. Dustin Galmore. Mr. Galmore, how are you doing?
Great, Judge. How you doing?
I'm doing fine. Now, Mr. Galmore, I see that Mr. Westbury has a felony case set for
February 14th.
February 14th. You want the case set on that same date?
I do.
Okay. Mr. Westbury, this case is gonna be set on the same date of your felony case, which is February 14th. Your attorney is gonna get you a reset. He needs to go over there and sign it. Once you get the reset from your attorney, you'll be free to go.
Another one, Janera Granger. She's on the pretrial docket. All morning, but I don't see her all of a sudden.
Would you please?
She was in the courtroom until at least about 5 or 10 minutes ago. She may have had to go in the ladies' room.
This is a case that followed me from Judge Wood's court.
Oh, I did? Okay.
Yes, Your Honor.
You still be in a pain.
Ms. Granger, would you please come forward? This is cause number 326095, case of South State of Texas versus Janera Granger. Ms. Granger, how are you doing? That's good. Could you check and see if we have bond conditions in this case? This was a case of transfer.
She's been in this court several times already.
She
At
has?
least one other time.
It can only have been like once. I think.
Check, I didn't. Case number is 326095. You don't, okay. Mel, could you reach for that blue folder? Need to give Ms. Granger some bond conditions. Thank you. Could you make me a copy of this? Now, let's see. This is cause number 326095. Case is style of state of Texas versus Janera Granger. We have Ms. Granger present in court with her attorney, Mr. Dustin Galmore. Mr. Galmore, Ms. Granger's case is set on the pretrial conference plea docket. Mr. Galmore, do you have an announcement that you'd like to make in Ms. Granger's case?
Yes, Judge, we want a trial.
You're gonna reset it for trial?
Yes, as soon as possible, if you don't, the court will accommodate that.
Will,
Because she was set for trial for a while in County Court 3 before it was transferred over, so the case has been going on for quite a while.
okay, well, you got a bunch of cases in that same
Well, I understand.
category
I
with
understand.
COVID. Yeah, you know, we was shut down for several months. Cases not back. Okay. We're gonna reset Ms. Granger's case for trial. Mr. Galmore, would you please hand this to your client, Ms. Granger? Ms. Granger, your attorney just your attorney has handed you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document? I will go over this document, which is reads, following arrest and or accusation in County Court at Law Number 2 of Jefferson County, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. And the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply to you because that only applies in a DWI case. In your case, it's not a DWI case. Now, Ms. Granger, if you violate any one of the conditions of this bond, your bond can be forfeited. And if your bond is forfeited, that simply means that you'll be arrested and put into Jefferson County Jail. Do you understand that?
Yes.
Now, Ms. Granger, your case has been reset for trial. Could you give us a trial date?
3/14.
Okay, your case has been reset for trial on March 14th of 2022. You can stand on the 4X, you get your reset from your attorney. Once you get your reset from your attorney, you'll be free to go and you have a blessed day.
I have a question.
You ask your attorney first. David Alexander Asagera Borjas. And we're in session in cause number 327-860. Case is style of State of Texas versus David Alexander Asagera Borjas. Mr. Asagera Borjas, is that your full name?
Yes, sir.
Mr. Asagera Borjas, would you please raise your right hand? Mr. Asagera Borjas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Mr. Asagera Borjas, you may put your hand down. How are you doing?
Doing good, sir. How are you?
I'm doing fine. Thanks for asking. And Mr. Asagera Borjas, you're here represented by your attorney, Mr. Dustin Galmore. Mr. Galmore, do you have a record in Mr. Asagera Borjas' case?
We do, Your Honor.
Mr. Asagera Borjas, I have before me a document that's titled information. In this document, which is styled the State of Texas versus David Alexander Asagera Borjas, it alleges that on or about July 19 of 2020, while you're in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed to class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Asagera Borjas, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Asagera Borjas, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you are guilty?
yes, sir, I'm guilty.
Okay, now, Mr. Galmore,
Yes, Your Honor.
thank you. You checked the wrong box. You checked, it should be class A. It's class A. Okay. Mr. Asagera Borjas, I have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
You notice that there is one box that's checked. And this box that's checked states that this is a class A misdemeanor. And the range of punishment for a class A misdemeanor is confinement in jail for a term not to exceed 1 year, a fine not to exceed $4,000 of both such fine and confinement. Do you understand the range of punishment?
Yes, sir.
On page 2 of the same document, there are a set of initials, D-O, on a line next to a box that's checked, guilty. Do you place your initials on this document?
Yes, sir.
And on the next page of the same document, Mr. Asagera Borjas, there's a signature above the line that is titled defendant. Did you sign this document?
Yes, sir.
On the next document, this document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document? There's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
There are two boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Mr. Asagera Borjas, I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes,
Mr. Asagera Borjas, prior to signing and initialing these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State's Exhibit Number 1?
Yes, Your Honor.
No objection, State's Exhibit Number 1 will be admitted. Mr. Galmore, you've advised and counseled Mr. Asagera Borjas. Is there any evidence that he is currently mentally incompetent to stand trial?
No.
Mr. Asagera Borjas, your attorney, Mr. Galmore, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Asagera Borjas, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea of guilty and waivers are freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do you have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, the agreement is for 180 days in jail, probated over a term of 1 year, an $800 fine, 60 hours community service, standard DWI conditions to include DWI classes and drug and alcohol assessments, and at the defendant's request, a portable interlock device.
He doesn't have a vehicle?
He has more than one vehicle, and so.
Wow.
The,
Yeah.
we've done this before with good cause shown, court can order a portable breath device. The portable breath device will require him to blow into it 3 times per day. That means that he will not be able to drink regardless of whether he's driving a vehicle or not.
Yeah.
page one on the fifth. Break it down. Yeah. Okay.
Okay, now, pursuant to Article 42(8.408), Section E-2, says the judge may waive an ignition interlock requirement under Section E1 for a defendant if, based on a controlled substance or alcohol evaluation of the defendant, the judge determines an interest in the record that restricting the defendant to the use of ignition interlock is not necessary for the safety of the community. And also in F, it says that the court shall require the defendant to obtain an ignition interlock device at the defendant's own cost before 30th day after the date of conviction, unless the court finds that to do so would not be in the best interest of justice and enters a finding on the record.
Right. And so what our argument to the court is that the portable is much more restrictive than an interlock device. An interlock device in his vehicle, he could drink at home and just choose not to drive that vehicle. And even though there'd be a violation of his probation, there would be no way for, his probation officer to actually know that. But a portable device is set up to where he has to blow in the morning, in the afternoon, and at night before bed. And so it basically makes it impractical that he can drink at all, regardless of whether he's driving a vehicle or not. And so with that device, if he decides to drink at any time for any reason, regardless of whether he's driving a vehicle, probation will be notified that he's drinking.
Yeah, but he can drink, get in a vehicle and drive. And before even probation is notified, probation wouldn't be able to stop him from driving.
Well, that's true, but I mean, you can also drive a vehicle without an interlock device. So-
Well, and yeah, that'd be a violation too, but I don't think it's in the public's interest or the safety of the public. I think it's best, the public is more safe that he does not drive a vehicle that does not have an interlock device on it.
Well, I understand the court's logic. However, like I said, with the portable device, it ensures he's not drinking at all. With an interlock device, it
Well-
ensures he does not drive that vehicle.
Well, I mean, the portable device don't ensure that he doesn't drink, but it doesn't stop him from drinking. He still could drink. The only thing the portable device says that, he has alcohol in his system. And he can just go get in a vehicle with alcohol in his system because the vehicle is gonna start. There's nothing there to stop the vehicle from starting.
Just like if he were to drive another vehicle with no
All right,
interlock.
I understand that, but I know the order is he's not to drive any vehicle. Any vehicle that he own or operate should have a interlock device on it.
I have a moment to confer with Mr. Galmore.
Yes.
Maybe we can resolve this situation.
Okay,
Thank you, Judge.
all right. Okay, the quarter. You
Yes,
you
Your
had
Honor.
a statement you'd like to make to the court?
Yes, Your Honor. The state, if the court would approve it, has reached amended terms on the plea negotiations, and the state would be willing to reduce this to a Class B misdemeanor in exchange for increased fine amount.
Okay, well, y'all will have to redo the paperwork and
Right,
everything.
we'll redo the paperwork
Okay.
and remove the interlock issue.
Oh, let me see, what was this? Oh, just, okay.